you say that one more time, please? Yes.
538 and.
Okay, so I want to start right with. Alan has been very gracious and to give us some education on fair housing. In your packet that Stephanie has just passed out, you will find his bio. He is the president of the Title Company of the Rockies. And he just taught a class up here last week, or the 27th.
Oh, yeah.
So, yeah, so we're very excited to have him come back. And he grew up in a small town from Minnesota, farm town, a graduate of, I'm not gonna read this.
You don't have.
We have no time. We love you. Thank you so much for coming. He knows what he's talking.
You can take a look at the bio if you'd like. All right, ready to go?
That's good.
All right, so those of you that have a real estate brokerage license, you can get 1 hour of credit for this class. I primarily teach this class for brokers for continuing education purposes, but I was asked to do it for general purposes as well. So I'm just gonna get off into it. We're gonna talk about fair housing, okay? And fair housing permeates the real estate industry. I'll just say, pretty much anytime there's any real estate activity, related real estate activity, you have to be aware of fair housing laws on both the federal and state level. So I'll kind of cover the history of fair housing. We'll talk about federal fair housing laws, and then we'll also talk about Colorado's fair housing laws. And interestingly, Colorado was one of the first states to actually legislate fair housing laws back in the 50s, well before they even did it at federal level. Okay, and just remember that state law could be a lot more expansive than federal law. And we'll talk about that. You guys ready to go? I'm gonna walk around. If I bug you, tell me to move, okay? All right, so the Federal Fair Housing Act protects people from discrimination when they are renting or buying a home, getting a mortgage, seeking housing assistance, or engaging in other housing related activities. I would say almost everything housing related. Intended as a follow-up to the Civil Rights Act of 1964. The bill was subject of contentious debate in the Senate, but interestingly, it was passed very quickly in the House of Representatives in just days after the assassination of Dr. Martin Luther King. The Fair Housing Act stands as one of the final great legislative achievements of then the civil rights era. So despite prior decisions such as Shelley versus Kramer in 1948, and Jones v. Mayer in 1968, which outlawed the exclusion of African Americans or other minorities from certain sections of cities, race-based housing patterns were still in force in the late 60s. So those that try to challenge them were often still met with resistance, hostility, or even potentially in violence. Okay. Meanwhile, a growing number of African American Hispanic members of the armed forces fought and died in the Vietnam War. On their home front, their families were still having issues with renting or purchasing homes in certain residential areas simply because of their race or their national origin. So from 1950 to 1980, the total Black population in the United States urban centers increased from 6.1 million to 15.3 million. During that same period, white Americans steadily moved out of the cities, sometimes called urban flight, right? And taking many of the employment opportunities African Americans needed into the communities where they were not welcome to live. So this trend led to the growth of urban American, what were then called ghettos, or inner city communities with high minority populations that were plagued by unemployment, crime, and other social ills. In 1988, Congress passed the Fair Housing Amendments Act, which expanded the law to prohibit discrimination in housing based on disability or on family status, such as examples of pregnant women or the presence of children under 18. And we'll dive into this subject by subject as we move forward. These amendments brought enforcement of the Fair Housing Act even more squarely under the control of HUD. HUD, referred to as the Department of Housing and Urban Development, which then sends complaints regarding housing discrimination to be investigated by what's called FEO, which is the Fair Housing and Equal Opportunity Office that acts as an enforcement arm with HUD. The Fair Housing Act covers most housing. In very limited circumstances, the act exempts owner occupied buildings of no more than 4 units. Single family houses sold or rented by the owner without the use of a broker. Okay, and housing operated by religious organizations and private clubs that will limit occupancy to its members. The Fair Housing Act prohibits discrimination by direct providers of housing, that includes landlords, real estate companies, property management companies, as well as municipalities, banks, or other lending institutions, including homeowner insurance companies, whose discriminatory practices make housing unavailable to those protected classes. One of the central objectives of the Fair Housing Act, which Congress enacted in 1968, was to prohibit race discrimination in the sales or rental of housing. Nevertheless, more than 30 years later, race discrimination continues to be a problem in housing in the United States. So what are we talking about? Let's start with that. Who is a protected class? Okay, so on the federal level, from Fair Housing Act that was put into place in 1968, there are 7 protected classes. Okay, they are race, color, national origin, religion, sex, familial status, and disability. Okay, we'll tie into disability into a few other statutes, such as the American Disabilities Act, as we talked through this today. So, what is prohibited in the sale and rental of housing at the federal level? It's illegal discrimination to take any of the following actions because of race, color, religion, sex, disability, familial status, or national origin. So the examples are refusal to rent or sell housing because of a protected class, because someone falls in a protected class. Refusal to negotiate for housing, right? Otherwise make housing unavailable. Yeah, I'll talk through some examples, but it's like, oh no, I rented that apartment out yesterday, when you really didn't. Because someone was exposed to something that could in fact be someone from a protected class. Set different terms, conditions, or privileges for the sale or rental of a dwelling. You have to treat everybody equally, right? Provide a person different housing services or facilities. The classic example used to be, just for point of reference, single persons are in Tower A, families can only be in Tower B, and families cannot use the pool. That used to be, a normal practice. You can't do that anymore. Okay, everybody needs to be able to use facilities and have the same rental opportunities or purchase opportunities. Provide falsely denying that a housing is available. Falsely deny that housing is available for inspection, sale, or rental. Make, print, or publish any notice, statement, or advertisements with respect to sale or rental of a dwelling that indicates any kind of preference, any kind of limitation, or overall discrimination. That's illegal. Impose different sales prices or rental charges for the sale or renting of a dwelling. Use different qualification criteria or for application processes for sale or rental standards, procedures, such as income standards, application requirements, application fees, credit analysis, sale or rental approval. It needs to be the same for everybody. Other activity. Evict a tenant or a tenant's guest because they're a member of a protected class. You can't do that. Harass a person. Obviously, you can't do that. Fail or delay performance or maintenance of repairs on a dwelling. Limit privileges, like I referenced earlier. Discourage the purchase or rental of a dwelling. I'll give some examples of that. You might not be comfortable in this neighborhood, but over in this neighborhood, you might be very comfortable. Can't do that. You can't talk like that. You can't steer people like that. Right? Assign a person to a particular building or neighborhood or section of a building as a reference for profit, persuade, or try to persuade homeowners to sell their homes by suggesting that people of a particular protected class are about to move in their neighborhood. Those folks are about to move in your neighborhood. That's called blockbusting. It's very, it's totally illegal. Refuse to provide or discriminate in terms or conditions of homeowners insurance because of protected classes, or deny access or membership to the multiple listing service that your local board of realtors would have access to. Or real estate brokers organizations. Okay. Other examples to kind of drive this home. A landlord says that an apartment is available when a prospective tenant calls and inquires over the phone. But seeing that that person who inquired is actually an African American descent, says the apartment has just been rented. Upon hearing an inquiry from a member of another race, the landlord said it's available again. That's completely illegal. Okay, and protected. Real estate agent refuses to show a house for sale in a specific neighborhood because of protected class, or conversely, steers a buyer to a different neighborhood when they are asked to see a property elsewhere for the same price range. Okay, a mortgage lender charges an applicant a higher interest rate or for their loan because the home is predominantly Latin, when a predominantly white neighborhood, or steers a borrower to a loan less favorable terms. Okay. You can't do that. That's called redlining. A modern multifamily condominium fails to comply with accessibility requirements for buildings erected after 1991, such as a prospective wheelchair-bound buyer can't access a unit or the parking lot. That also ties in the American Disabilities Act. Okay, and then a rental agent refuses to rent an apartment to a single woman who has several children. You cannot do that. It is illegal. Okay, so I'm going to talk about specific pieces of the real estate industry now. Okay, everybody good? Hanging in there? All right. It is illegal discrimination to take any of the following actions based on a protected class in mortgage lending: refuse to make a mortgage loan or provide other financial assistance, refuse to provide information regarding loans overall, impose different terms or conditions, or set interest rates, fees, or points for a loan based on classes. Discriminate in appraising the dwelling, appraisal, that's come up. Condition the availability of a loan on a person's response to harassment. Refuse to purchase a loan. Okay, there are also fair lending laws that also overlap on this, that apply to banks and other lenders on top of fair housing. Okay, and advertising and marketing, probably more within the context of brokerage firms. Discriminatory housing advertisements are illegal under the Fair Housing Act and other federal civil rights laws. Note that HUD's housing programs, certain types of affirmative fair housing marketing is required by federal law. So what's prohibited, what type of affirmative fair housing marketing may be required. So in nearly all housing, including private housing, public housing, and housing that receives federal funding, the Fair Housing Act prohibits the making, printing, or publishing advertisements that indicate a preference, limitation, or discrimination because of protected class. The prohibition applies not only to those representing a property, but it also applies to the actual publisher of the information. So if a newspaper were to publish something that had that type of a preference, they could also, besides the broker, be found to have violated Fair Housing Act. Okay, so it also applies to the advertisement itself, violates the act, even if the property being advertised might be exempt from provisions of the act. Other civil rights laws may also apply regarding discriminatory advertising practices. Examples that may violate the act include phrases such as "no children," "no children allowed," which indicates discrimination based on familial status; "no wheelchairs allowed," which indicates disability discrimination. Hopefully those types of examples help kind of drive the message home, right? Federal law requires that applicants for participation in HUD subsidized or unsubsidized housing programs pursue affirmative housing marketing policies. This helps ensure that individuals of similar income in the same housing market area have a wide range of housing choices regardless of their protected class. Okay, disability. We talked about that being a protected class. Let's drill down into disability. Prohibits discrimination on the basis of disability in all types of housing. The act defines persons with a disability to mean those individuals with mental or physical impairments that substantially limit one or more major life activities. That's kind of the overall catch-all for disability, and that spills into the ADA and some other legislation as well. So mental and or physical impairments that substantially limit one or more major life activities. That may include such conditions as blindness, hearing impairment, mobility impairment, HIV, mental retardation, alcoholism, drug addiction, chronic fatigue, learning disabilities, head injuries, and mental illness. The term major life activity may include such things as seeing, hearing, walking, breathing, performing manual tasks, caring for oneself, learning, speaking, or working. The Fair Housing Act prevents persons who have a record of such an impairment. It's there. And are regarded or are regarded as having such an impairment. However, current users of illegal controlled substances, persons convicted for illegal manufacture of a controlled substance, sex offenders, and juvenile offenders are not considered to be covered by the Federal Fair Housing Act as it relates to disability. So those would be exemptions. Okay. So illegal controlled substance convicted of illegal manufacture of controlled sex offenders, juvenile offenders would not be considered disabled. And the Fair Housing Act provides no protection to individuals with or without disability who also would present a direct threat to the persons or properties of others. It's kind of a catch-all phrase. If they potentially could provide a direct threat, they would also not have the protection of a disability as a protected class. Okay, who is that? Someone poses a direct threat, may be an individualized basis, but it cannot be based on general assumptions or speculation. The Division's enforcement of fair housing protection for persons with disabilities has concentrated on two major areas. One is ensuring that zoning and other regulations concerning land use are not employed to hinder residential choices, unnecessarily restricting communal or congregate residential arrangements such as group homes. Got to be careful with our zoning as it relates to group homes. Second area is ensuring that newly constructed multifamily housing is also in accordance with the Act requirements so that accessibility and usability of people with disabilities, particularly those with wheelchairs, ties into ADU also. There are other federal statutes that prohibit discrimination against individuals with disabilities. The American Disabilities Act, which is also enforced through the Disabilities Rights section of the Civil Rights Division at a federal level. Race or color, another protected class. Okay, the overarching purpose of the Fair Housing Act was to prohibit race discrimination in the sale or renting of housing. Right, as we talked about, that's still an issue today. The majority of the Justice Department's patterns or practice cases often involve claims of race discrimination. Sometimes housing providers try to disguise their discrimination by giving false information about the availability of housing, either saying that it was available, now it's not, or steering potential home seekers to other certain areas based upon what race they are. Individuals who receive such false information or misdirection may actually have no knowledge that they have actually just experienced discrimination. Okay. Most of the mortgage lending cases that are brought by the department under the Fair Housing and Equal Credit Opportunity Act have alleged discrimination based on race or color. Some of the department's cases also allege that municipalities or other local government entities violated the Fair Housing Act when they denied permits or zoning changes for certain housing developments or regulating them to predominantly minority neighborhoods because the prospective residents were expected to be predominantly African American or another minority. Okay, topic of religion as a protected class. This prohibition covers instances of overt discrimination against members of a particular religion, as well as direct actions such as zoning ordinance designed to limit the use of private homes as places of worship. In a number of cases filed since 1968 alleging religious discrimination, it's a small amount of that compared to others. Race is still number one in national origin. The Act does contain a limited exception that allows non-commercial housing operated by religious organizations to reserve such housing just for those that are practicing that religion. Okay. National origin. This can either be based upon the country of an individual's birth or where his or her ancestors originated from. Census data indicates the Hispanic population is the fastest growing segment of our nation's population. As an example, the DOJ, the Department of Justice, has sued lenders under the Fair Housing Act and Equal Credit Opportunity Act when they have found lenders imposing more stringent underwriting standards on loans or loans on less favorable terms for Hispanic borrowers. The DOJ has also sued lenders for discrimination against Native Americans. Other areas of the country have experienced an increasing diversity of national origin groups within their populations. This includes immigrants such as from Southeast Asia, Hmong community. I grew up in Minnesota, in St. Paul, Minnesota. There's a very large Hmong community, extremely large. Former Soviet Union, we are seeing a number of Ukrainians have migrated to the United States as an example, and other portions of Eastern Europe. So the DOJ has taken action against private landlords who have discriminated because of a person's national origin. Okay, familial status. So in addition to prohibiting outright denial of housing to families with children, the act also prevents housing providers from imposing any special requirements or conditions on tenants with custody of children. Not only could those be children of the residents, they could be adopted, they could be under foster care. It includes all those types of children. Okay, for example, landlords may not locate families with children in any single portion of a complex, place unreasonable restrictions on the total number of people who reside in a dwelling, although zoning laws could apply. You know, at the same time, separately, there may be a restriction on how many folks can be in a dwelling based on zoning laws or other safety issues. Place unreasonable restrictions, or limit the access to recreational services. I mentioned the pool. Everybody in that building gets to use the pool. Everybody in that building can't use the pool. Can't do that. Okay. In most instances, the amended Fair Housing Act prohibits a housing provider from refusing to rent or sell to families with children. That also includes expected parents. You can't evict somebody because they're an expected parent, or try to evict somebody. Some facilities may be designed. The only out on this is a senior living. So if it's a properly registered senior living community, Del Webb community down south, if it's properly registered, that community would be exempt from some of the fair housing protections. So in other words, a 55 and older community can say children are not prohibited to live here permanently. That's a policy issue that the government has decided. You can argue one way or another if it's a good policy, but senior communities have an exemption. Okay, just FYI. Okay, familial status, families with children under 18 could includes pregnant persons, any person in the process of securing legal custody of a minor child, whether adopted or foster. Okay, examples of familial status discrimination include refusing to rent to families with children, evicting once a child joins a family, either through birth, adoption, or custody, requiring families with children to live on specific floors or in specific buildings, imposing overly restrictive rules about the children's use of common areas such as pools, hallways, and other open spaces on the overall campus, and advertising that prohibits children. Strictly, you cannot do that whatsoever. Okay, LGBTQ. So persons who identify as LGBTQ, who believe they have experienced housing discrimination, may be able to pursue a claim under some of the following: Fair Housing Act, if they have experienced discrimination under one of the Act's 7 protected classes, which includes sex or disability, as we've talked about. HUD's Equal Access Rule, or state or local anti-discrimination laws, which specifically include sexual orientation or gender identity. Colorado has those protections, and I'll touch on those yet today. Okay. So as an example, excuse me, transgender, sorry about that. The transgender woman is asked by the owner for an apartment building not to dress in women's clothing in the common areas of the property. This may violate federal fair housing prohibition against sex discrimination, which includes discrimination based on non-conformity with gender stereotypes.
So how is this regulated? First of all, you have to keep good records. And you have to file a complaint. Once you file a complaint with HUD, HUD will turn it over to FEO, which works to eliminate discrimination, promote economic opportunity, and achieve diverse and inclusive communities. So FEO's primary focus is to eliminate discrimination, promote economic activity, make sure that we have inclusive communities by leading the nation in enforcement, administration, and development of public understanding of the federal fair housing policies and enforcement of its laws. Okay, so this could include other things besides the Fair Housing Act. They also can enforce Civil Rights Act. There was a Community Development Act, 74, Rehabilitation Act, ADA, Architectural Barriers Act, Age Discrimination Act. There's lots of other legislation that they would have enforcement capability to do. So they investigate fair housing complaints. They conduct compliance reviews, they ensure civil rights and HUD programs, and they manage overall fair housing grants. How do you file a complaint? Examples include when you feel you discriminate against for public housing, affordable housing voucher programs, or any HUD substance abuse treatment programs, residents of homeless programs. So if you believe you have been discriminated against in any housing or community development program, you file a complaint with FEO. Okay. They also oversee other HUD-funded programs, including sub recipients that may have civil rights obligations also enforced, as mentioned, and these types of programs. So CDPG, Home Partnership, Emergency Solutions Grants, HOPLA. Section 8, clearly under HUD, Section 811, elderly housing, as well as homeless assistance programs. Sometimes the Department of Justice gets involved. They may also then file a suit both under the Federal Fair Housing Act for pattern of discrimination or denial of rights of group raised an issue as far as general public importance. So whether force, where force or threat by force is used to deny or interfere with housing rights, the DOJ may also institute criminal proceedings. Okay. Fair Housing Act provides procedures for handling individual complaints filed with HUD. They can turn it over to FEO. And if FEO feels that it's at a higher level, they can also refer that to the Department of Justice to also bring a civil and or criminal matter as well. You'd be represented by DOJ attorneys in the process. If the individual's complaint was part of a larger pattern of discrimination, the DOJ could find broader charges seeking relief for other individuals. They could pull more people into the action and go after also civil penalties, that is a fine paid to the government. If the individual seeks an administrative hearing, HUD attorneys and through administrative, that may take some time. If I'm looking for a quicker process, I may ask that HUD represents me in an administrative law process instead. So there's a different administrative law judge would be appointed. Takes a lot less time. You may be foregoing some abilities to get some additional damage. Treble damages is a lawyer, fancy lawyer word for triple damages. But no punitive damages can be awarded through the administrative process, although it may not be a lot quicker. And that'll be something that you can talk to them about, versus one path or another if you find yourself wanting to file a complaint. You can also retain your own private attorney. Both types of courts can order injunctive relief, give written opinions, and any appeals can be brought to the U.S. Court of Appeals with the DOJ. So housing and civil rights attorney say that providing housing discrimination, unless it's overt and obvious, can be difficult. That's one message, right? Sometimes you don't even know if it may have happened to you, right? So the point of it is, it's very difficult at times to expose it. If you feel that you have experienced discrimination, the best thing to do is keep a lot of really good paper records. Document everything so you have that for future reference. Written records are very helpful. And they also suggest that individuals who believe they have been a victim of discrimination contact their local fair housing center or an attorney to get some guidance on what their next steps should be. Okay, that's federal. Everybody with me? All right, we're gonna dive into Colorado next, okay? Colorado has Department of Local Affairs, Division of Housing, is committed to affirmatively furthering fair housing. The following resources are available to help our partners comply with fair housing requirements. We have a Civil Rights Division, which investigates complaints of discrimination in employment, housing, and places of public accommodation. Okay, the Colorado Civil Rights Division has the ability to investigate a complaint. The alleged discrimination must be based on the complainant's protected class. Okay, we'll talk about Colorado protected classes. What is disparate treatment? That's a word that's kind of thrown around. Disparate treatment discrimination occurs when an employer, housing provider, or place of public accommodation treats people differently based on or because of their protected class. Okay. The impact is discrimination occurs when a rule, policy, or procedure is disproportionately and adversely impacts a particular protected class. FYI, I kind of let the cat out of the bag. The state of Colorado was the first in the nation to pass statewide fair housing laws and bar discrimination based upon that with legislation that was put out in 1959, decade before the federal law was passed. Okay, federal fair housing classes are provided by DORA. This ties into brokers with licenses. The Division of Real Estate provides some other educational opportunities regarding fair housing laws for real estate brokers. Okay, so what do we have in Colorado? It's called CADA, Colorado Anti-Discrimination Act. That's Colorado state version of the Civil Rights Act, Age Discrimination Employment Act, and the ADA, all rolled up into one state statutory framework. Okay, so houses offered for sale, lease or rent, or transfer of ownership is covered by fair housing under CADA. Housing not covered by CADA is any room or unit offered for lease or rent in a single family dwelling, maintained and occupied in part by the owner or the tenant of such dwelling. So that's a safe harbor. So if we're only dealing with a room or a unit offered for rent or lease in a single family dwelling that's occupied by the owner or a tenant, that's excluded. Okay. Additionally, in limited circumstances, the prohibition against discrimination based on familial status does not apply, as I mentioned, for senior housing. The sale of a single family home without the assistance of advertising broker or other housing places. I mentioned that in the federal level, state level too, FSBO. FSBO is exempt. Okay. CADA's fair housing provisions also apply to real estate transactions, such as making loans secured by property, constructing, improving, and maintaining dwelling, or selling, brokering, or appraising residential real property. Okay, so let's talk about some examples under Colorado law. Refuse or rent to sell, unequal terms or conditions. This is very similar to what we talked about on the federal level. Refuse reasonable accommodations or modifications necessary to accommodate a disability. Redlining, that's a practice that puts housing related services out of reach for residents of certain areas based on race or ethnicity. It's called drawing red lines around the map. That's where that term comes from. You cannot do that. Around minority neighborhoods on a map of denying loans for purchases. Steering is a practice by usually a real estate agent of maneuvering a client or a tenant away from a minority group, away from considering a home in a predominantly white neighborhood, as an example. Okay, you cannot intimidate, coerce, threaten, or harass. You cannot advertise, again, like federal law, preference or limitation. You cannot misrepresent availability. And you cannot retaliate against a person engaging in protected class activities. You can't retaliate someone that's complaining that they feel that they've been discriminated against. All right, in Colorado, protected classes are expanded from federal law. You have your 7 primary federal protected classes, right? But on Colorado, we also have sexual orientation, which includes transgender status and gender identity. We also have marital status. Just realize I didn't spell it. First time ever. Familial status, national origin, ancestry, and just recently, the last 2 years, was added source of income. Okay, you can't discriminate against someone that may be receiving some federal assistance voucher programs. You can't discriminate based on their source of income, especially if it's coming from assistance programs. Okay, can't do that. And then just this year, this past legislative session, not the current one, veteran or military status was also added as a protected class in Colorado. Okay, that's brand new. So persons who have engaged in protected activity, such as making a plain discrimination or requesting reasonable accommodation, are protected from retaliation. One thing just to let you know, counties and municipalities can also expand protected classes. Boulder, Aspen have local protected classes that expand even out of state law. So know your backyard is kind of the message, right? So you can get down to a local level and local government can expand protected classes if they choose to do so. All right, kind of wrapping up. Let me just give you some real world examples. This stuff has happened and kind of hopefully reinforces some of the messaging from tonight that we talked about. So a recent world example, this was 2020, it's also fairly recent, just a few years ago. This took place on the East Coast. A lot of this takes place on the East Coast. I don't know why, but it does. A recent Newsday article unveiled an undercover operation. Okay, the first thing is that there are actually folks out there that are testing, kind of like a secret shopper. They're out there actually working on behalf of the government and doing testing. So they engage in conversations with real estate brokers, with lenders, and they represent themselves as a potential borrower or a buyer. Okay, and that's how this stuff gets uncovered. A lot of times, unless there's also been a complaint and then they've inserted themselves in the situation. So several New York-based real estate agents were accused of steering. Right, we talked about not this neighborhood instead. Okay, so a fair housing violation that involves influencing a buyer's choice of communities based on the buyer's race, color, religion, gender, disability, familial status, national origin, right? These were some actual comments that came out of the investigation, just to kind of drive this home. Follow the school bus. See the moms that are hanging out in the corners. When I say that, I mean it's always women. Okay. Some of them are not as nice. Belmont, most of Hampstead, Roosevelt, Baldwin, Freeport, maybe not as nice in terms of statistics. Okay. Whenever you're going to buy diapers, during the day, why don't you go at 10 o'clock at night instead and see if you like the area then? I have to say it without saying it, Just because you think I would rather be here or because I'm a certain race, you think that I should be over there. But what about my choices of where I want to live? That was one of the questions the tester was using to solicit this type of feedback. Okay. All right. So wrapping it up. Like I said, I teach this class to brokers on a national level. The National Association of Realtors has a new campaign out. They call it ACT. And it's really emphasizing accountability, culture changes, and training with the 1.4 million realtors across the country. I think it's a good little comment. There's no reason to believe that practices that were unveiled by the Newsday article are limited to Long Island. This came from a former HUD investigator. I oversaw federal government enforcement of the Fair Housing Act, and we saw these similar practices happening throughout the country. Okay, we believe it's up to NAR This is a realtor's pledge. It serves no value to realtors to be associated with discrimination of any kind. It harms their reputation, and it's a very poor economic model. Discrimination is bad for business and bad for society, and brokers have a code of ethics to say this is just simply wrong. It's bad practice. Okay? How'd we do? Good? Yeah. Anybody have any questions? Yes, sir.
I didn't see like citizenship or immigration status in there, with country of origin.
Probably tie back into that. A lot of this is all going to be very specific, factual based. Creed, is similar to religion. A little, ancestry could tie into that, country of origin can tie into that. So I have to know the specific fact base, but on those topics, my gut reaction is we probably touched on one of the 7 or of the 12 protected classes at the state level. That's not to say, so the point is, those are kind of general catchphrases, but you may have certain circumstances or instances where that all rolls up, possibly into one of those major topics, but it might be, a couple of the other issues that you mentioned. That's a good point.
So I guess on that note, would say asking for citizenship status be included as a violation of I'm like,
Fair housing.
Yeah, no, so, there is state legislation that kind of ties into rental applications and different things. I am not gonna pretend that I'm me no practice no more, number one. And number two, I'm not gonna pretend I'm an expert in this, just like some other niches, but, there would be, the forms that are used for property management and for rental applications do have a foundation in what's permissible as far as what you can ask for. So, whether you're, I guess my analogy is by law, as an employer, you can still ask that question, and you need to clear an I-9 out with the proper documentation. So I'm not aware that there's a prohibition about asking that and having that be part of the application process. And that's probably as deep as I can go personally. Does that make sense? Yeah.
you mentioned the source of income as a protected class under the state
Yeah.
limitations. So is source of income limited to federal assistance, or does it extend further than that?
It could extend. I'm pretty sure I just know a little bit about the statute. Once again, I'm gonna stay high level. I don't think there's a differentiation between federal, state and local. I think on Colorado's law, if there is some sort of assistance, support, especially tied to government programs, you can't discriminate an applicant simply because they're getting some outside support outside of their livelihood.
So the
That's
intent
the intent
of that is that recognizing the assistance versus type of employment or
Right.
location of employment.
Right. So if someone happens to be employed, but they've also got some assistance coming in, you as a landlord cannot discriminate. As long as they qualify and they can pay the rent from the way it looks. You can't say, well, that person has that job and only that job and so I want to rent to them versus that person that also is getting some assistance. That's the intent of it.
Okay, thanks.
Anything else? All right,
I do have a question.
Yeah.
So this came up in asking or thinking that prioritizing. A lot of the federal rules seem to say can't discriminate against, and then the Colorado rules seem to address it in a more vague language of discriminate against or encourage
right.
housing of. And this came up in our conversations on can we prioritize families or, I guess that's, I'll use that as. an
So in
example.
other words, instead of discriminating against, we're gonna put a priority there. That seems to be something that's happening quite a bit.
It is happening in a legal way.
I
Or
Yeah.
not a legal way.
So I-
Housing for housing, you can't.
You can't, but I know, I'm just saying, just based on information. Yeah, it's a little different, but I just know that there have been some programs that have been put into place, at least on the federal level in the last few years. That provides a preference and,
My concern.
I would say get a hold of somebody that practices law in this area. If you really get down into getting that deep in the weeds with it.
We'll do that. My concern is that by prioritizing, then you are discriminating against folks that do not have that same,
Right? That makes sense to me.
Mhm.
I'm just saying, it's a little bit different twist on it.
I think the three of us that are realtors in the room with, they're housing. It's,
Yeah.
it's,
Well,
it's
just like
confidential.
realtors disclose,
Mhm.
right? Yeah, so I'm sorry, I don't have a specific answer for that, but I would. Yeah, I think it's good to be thinking about and talking about and take pause and just say, have we? Is this something that we'll consider to be compliant or not?
Yeah.
You don't want to have an unintended consequence,
Right.
right?
Do you know off the top of your head what those additional classes are that Boulder and Aspen including?
Not gonna guess, but I'll tell you what they're, just give me a second. They actually have them listed. You need to. What an appetite there, and that get through, let's see here, come on. Where's my finger?
Oh, can you,
There we go. Right. Close that out. And give me a second, I'll show you.
to the owl? Oh, yeah.
In the brokers have to take an update class with the division of real estate every year. And I teach that one too. And we're also doing did I get the right spot? Oh, shoot. There we go. There we go. Okay, so we kind of covered a lot of what we did today, not quite as deep. So I talked about Colorado state law, which we just covered. Here are examples: Telluride, political orientation, age, family responsibility, outside of familial status, so family responsibility, pregnancy and childbirth, Aspen, Crested View, in Boulder, political orientation, age, and family responsibility. Denver, parent with persons over 40 of age, and gender variances. So there's some more specific examples of what have expanded protected classes at a local level. Okay. Is that helpful? Yes. People over 40 in Denver. And then, I mentioned residential quite a bit. There may be a few nuances versus commercial property. So if you're dealing with commercial property, you have concern about whether or not fair housing law has been violated. We have to check in to make sure that it's covered. Colorado state law probably will cover it. Okay.
So, you mentioned earlier that some of the legislation does not cover if you are someone is renting a room in their house.
Yeah, so there are some,
So like, Craigslist ads, rent a room in my house,
yeah, so
et cetera, et cetera.
so under Colorado law, if I'm renting a room in my house and I own it,
Yeah.
or if I'm leasing it, and I have the right to go ahead and sublet a room, Colorado law may be exempt in that specific circumstance.
But the
Federal level, there is not the same exemption. You may find that as being something that could have been violated, state law is that. And then,
you see a lot of that, like
Right.
in Craigslist ads, that
Right.
rent a room in my house, but
right,
it can't be this, you can't be
right,
that, female preferred.
right.
Female not
So if
preferred,
it's a
et cetera.
single room in a single family dwelling and it's owner occupied or tenant occupied with right to sublet, there may be an exclusion from that. So, say it's. Right. They can put limitations or preference in it. If they are outside of, if they're in a safe harbor, in other words, if it doesn't apply. Yeah, that's how you'd have to think through that. And, we talked about reasonable accommodations today. That's a big issue with HOAs now. When you start talking about emotional support animals and service animals, you start talking about somebody wanting to put a wheelchair access into a property. Sellers don't necessarily have to deliver on a reasonable accommodation, but it always needs to be presented to an HOA. Most HOAs have policies they put in place now. Anytime you're presented with a reasonable accommodation request as an HOA, you have to parse through that. You have to determine, is it reasonable? Is it something that we feel comfortable providing the accommodation? And you could be challenged, and people have challenged it in court, and they have won. Both sides. I've heard about both sides in the last year. I've heard about cases, one over in Grand Junction, where someone was told they couldn't bring in an emotional support animal into the unit. It was a rental. They pushed it, and the court found that it was an unreasonable accommodation decision decided by the HOA. In that circumstance, they're all factually based. Another one had to do with husband and wife. This was also in Colorado, where the wife had an extreme pet allergy, dander allergy, extreme. She was exposed to it. She would literally get apoplectic. She could die. And they were planning on leaving and renting their house out for 6 months. They're taking a trip overseas. And there was a potential tenant that came in that wanted to bring a cat in. And they said, no, we can't do that. And that tenant challenged them. And the judge found that was a reasonable non-accommodation because the wife, if she came back and got into the house, she could die. Yeah. So the court found that under those specific circumstances, for them to not accommodate the request was compliant with law. So a lot of this stuff is all factually based ad hoc, depending on specific circumstance. Okay. Anything else? All right, well, hopefully that'll give you a little flavor of why we have those laws. What protected classes are and why there should be no discrimination based on those protected classes. Okay. All right, it was good being with you tonight,
Thank you.
and good luck with all your actions. Okay.
Okay, thank you for the presentation.
Sign in sheet.
If it's all done, there's 3 and it's there.
All right, leave the sign in sheet with you. Okay?
Fine. But it's just for the.
It's just for the brokers if you want to get a
Oh,
credit,
Oh,
okay?
got it.
So text for you brokers that took the class, she will email you your certificates, you get one or some credit, okay? All right, I'll stop talking and.
Thank you so much for the presentation.
Yeah, you're very welcome,
We
thank
really
you.
appreciate you coming.
Thank you. Moving right along, since our agenda is completely full. John, do you want to give your presentation on lessons I learned in 2020?
Yeah. I'm just saying.
Okay.
Yeah. Should be there.
And John, you'll have to connect to the projector to present on the screen, and I'll go along with you as you're talking on Zoom.
Like next one.
Yes, please.
Okay.
Chapin, will you help John with the?
Yeah.
Thank you. Expanding.
Get it, Sarah?
I did. Yep.
Sure.
On this side. Yeah, I've got like this.
Yeah, that's. I don't think it.
And when we put it over here, and we extend this to make it, yeah.
Okay, thanks. Hopefully it's a little less exciting than you thought about.
Oh, no.
Right here.
Oh, yeah, that's right. Let's see. Let's go a long way.
Bless you.
Do you want to share so you can,
Oh.
yeah, it might work better. Okay.
Okay.
All right. Is everybody ready? Well, thank you very much for having me. I just have a couple slides. I wanted to just show that I was just thinking, I've worked in the nonprofit sector for 46 years and been actively running and been involved for the past 30 years. And I have to say that the year 2020 was the most remarkable year I've ever lived through, experience. And this is, of course, when the pandemic hit, but I was hired here July 2019. You know, really honored to be here and serve this community. And in January, we had our annual retreat where we went through the strategic plan for the next 5 years. And it was really, I mean, our founding board really laid out a strong foundation and with some vision and wonderful vision for the future. And then March 14th hit. And that was when Governor Polis shut the state down. COVID hit. And let me see. And, so, you know, as you all know, most of our workforce works outside Lake County, primarily Eagle and Summit County, serving the hospitality and the ski industry. And when that happened, it was a serious situation for us. And just backtrack a little bit with the community fund. During the summer of 2018, we had a very serious wildfire season. And our inaugural founding board felt we really needed to develop a disaster relief fund just in case of fire and structural loss. And work with Colleen Nielsen, who's director of Lake County Public Health. And so the disaster relief fund was established for assisting and receiving donations in case there was serious damage from the wildfire season of 2018. Well, right after March 14th, I think within the next day, our board had an emergency meeting and said, you know, what are we going to do? We have a serious issue here to face. People are without incomes to pay for rent, pay for utilities. We're at 10,000 feet, it gets cold, can't pay for that. And so the disaster relief fund was pivoted, working with Colleen and Kaylee Ham, who was the director of the Office of Emergency Management, pivoted that disaster relief fund to work and help Lake County residents, primarily that have lost the ability to pay for rent and pay for utilities. And so Colleen and Haley met with a group of local citizens, residents in Lake County, brought together a full circle of Lake County and Lake County Build a Generation are two strong nonprofit organizations. And out of that was the Unmet Needs Committee was formed. And so I remember our board meeting, first we started talking about, well, we'll assist with rent, we'll assist with utilities, and how much do you have in the account? We had at that time $4,500 in our disaster relief fund. which wasn't gonna go far. So anyway, the momentum was started, boots on the ground. Unmet needs committee came together. And within 2 to 3 weeks, it was amazing. We started getting people donating to the disaster relief fund, to the Lake County Community Fund. And people started, this was, if you recall, 2020 was such a politicized environment. I mean, we were talking about COVID is a hoax, and this is pre-vaccine, everything. I mean, there was a lot of out there noise going on, primarily outside Lake County, but not a word in Lake County. And what to me was the most remarkable thing, we had county government, we had city government, we had individual donors. We had some major foundations outside of Lake County, like the Vail Valley Foundation, the Summit Foundation, all contributed to the disaster relief fund. And within about 4 to 5 months, the Lake County Community Fund, we had raised over $300,000. 100% of that funding went to utility and rent assistance. And these were for families that did not qualify for any kind of government aid. So this was the Unmet Needs Committee came together. We had 5 people on the committee. 3 of the members of the committee had lived experience as immigrants, and families could go to the Unmet Needs Committee and request help for rental assistance and utility assistance. And as you can see, as a community, within about 6-7 months, as a community, we raised over $700,000, which provided assistance for 721 households, representing 2,500 people, and 66% of the households have children under the age of 18, and 7% were Latino. And 44% of those asking for help lost jobs are in Eagle County, and 34% worked in Lake County, 22% in Summit County. So, again, this is, and I was during this period, as the funds were coming in and people donating stimulus checks. I mean, it was amazing how this community came together. And I was just waiting for somebody to say, hey, wait a minute, the politicization, the environment, and this was outside of Lake County, but not a word. People took care of their neighbors, made sure that people were housed, utilities paid. It was the most remarkable experience I've ever seen. So you're all familiar with the Urban Institute. It's that think tank in Washington, D.C. that does a lot of work in housing and urban work. But they did a study and surveyed 47 states in the United States to see how different communities handled homelessness or evictions because of the pandemic. And they ended up surveying Pennsylvania, Florida, Texas, and the 4th community that they surveyed was Lake County, because we stood out. And they interviewed Stephanie Cole, Full Circle, and just as a lesson of learning because what we did was so unique and how we came together. And, I have the paper from the Urban Institute that they wrote up about, how we handled it. And we had no foreclosures. Nobody was evicted during this period. But so to me, this experience just really, my faith in human nature that, we can come together and work together. It doesn't matter how you feel politically or whatever, but when we can work together and we can solve serious problems. And as you know, I mean, now there's a lot of divisions in this country, but to me, I'll never forget this year with Lake County as an example of what can be done. Government, business, the nonprofit sector, community, all came together and it was remarkable. So, I mean, and so I think, you know, the one lesson to me, you know, is that we can't work together and then, you know, the silos don't help, you know, having different silos, but if we can all work together, particularly Lake County, we've got a lot of issues here. We've got a lot of potential. We've got some fabulous assets and resources. And we're surrounded by phenomenal wealth. I mean, 3 of the wealthiest counties in the United States we're surrounded by, and just we have to work together as one community, just like we did here. And so anyway, thank you.
Thank you, John.
All right. I'll give you a sec to. Are you good?
Yeah, that's it. Yeah.
Sec then.
No, it doesn't matter.
Oops, circling back. To the agenda, we got the approval of February 15th minutes. Does everyone have a chance to look over those minutes?
Yep.
Does anyone have any changes?
Sorry, hold on. I was trying to look. I thought it might be. Since there's these bullets from the mayor on the climax, and says that the city would be willing to spend the 650,000. And it wasn't a discussion among the group, but a comment that I made about perhaps looking to like coordinate between the city and the housing authority, so that nothing's done in a vacuum or, I thought that was, I would like to revisit that, or I think that's a big point to make.
Is that
we
an
could
edit
include that
needed
in
for
there.
the notes?
Maybe in addition, I don't
Okay.
remember
What would
exactly
you like to add?
what I said.
We could add like a special note saying, emphasize some type of coordination with city and housing authority.
For like
Forward.
the acquisition.
Yeah.
And negotiation of the acquisition.
Any other amendments or changes to that? Do I have a motion?
Move to approve.
Oh, can I
You
just
have a
make
question?
sure I
Yeah.
got that right?
Yep.
So you would like to add that you propose we further discuss the regional housing authority and city collaborating to acquire the climax parcel?
Yes. I think that sounds adequate. Thank you.
Lovely.
Thank you.
Strive for adequacy.
Now do I-
Accurate and adequate. That is adequately accurate. I'll move to approve the February 15 minutes.
Sorry, I just saw one thing.
Yeah,
Looking at them again on the, when we presented, I'll be there. When I said we would have to create the LLC, I don't think it's us, it's JP Housing Trust or the Lura needs to do that, not the Regional Housing Authority.
Okay, cool.
Or like the, I don't know. Reed's doing all of it, we're not, like, she'll make that clear.
And you can say that he did create it with his attorney and attorney husband.
Are there any other- That's fine, I just, the other 2 bullets down.
Okay.
CHT. Me too.
A motion to include said amendments.
So moved.
Can I interrupt?
Yeah.
I don't, this is not, I had updated these minutes, correcting that. And also, RHA is not getting tax abatements, they're gonna be let's not approve these right now, let's.
Oh,
come back
that's
to
not
this.
the
This
right-
is not correct.
Okay.
Come back to it then.
Okay.
Table that until, the next meeting.
That's fine.
Great, moving right along to the adoption and discrimination statement.
Okay, so I just included that in your calendar invite, so look and see if you have it. I took a grant writing class and they, recommended that we have that, because for some grants we need to have that, so September drafted it. So you all able to see it?
Version of that.
You wanna see it?
More so just sign after. Cool, has everyone had a good chance to review and look over? Are there any comments or any questions regarding the policy choice? In that case, do I have a motion?
What number resolution was this?
I'm not gonna have to verify which one it is.
Okay. Well, substituting the appropriate resolution number. I'll move to approve resolution 23. Dash unknown. A resolution of the Board of Directors of the Leadville Lake County Regional Housing Authority adopting an anti-discrimination policy.
Do I have a second?
30 seconds. Quick.
Great, any other discussion?
No, thank you.
All in favor, please say aye. Aye. Any opposed? Any abstentions? Thank you. All were in favor. All right. Agenda, and Cisco and I will get that signed after.
Sign it now.
No, just.
No.
All right, so moving right along, to Chapin.
All right. So I'm gonna talk about three acronyms tonight, NHL district, ADUs and STRs. So those are the three things that are happening in my world that kind of affect the city. I'm gonna give the update to the board tonight. So first regarding the NHL districts, that's the national city's national historic landmark district. So that encompasses approximately 3/4 of the city of Leadville. So right now, the city has a historic preservation commission and a city code that requires new development within or modifications within the retail core, so that's everything along Harrison Avenue, or new residential infill anywhere within the historic district. So that would be a new house on a vacant property. Requires any of that kind of development to come in front of the city's Historic Preservation Commission and City Council to obtain approval. So in other words, there's not any kind of regulation for commercial development. So anything outside of
off of Harrison Avenue within the historic district. There's not any kind of regulation for, they doing a commercial development, or if you're adding on to a residential structure, making a significant modification to a historic structure. And so the Historic Preservation Commission has been working on proposed code amendments that would essentially capture some of those things that could potentially have could affect the character of the city's historic district. In particular, additions, modifications to structures, as well as just commercial development, although that's probably in this current market, we're not seeing as much of that. So the Historic Preservation Commission and the City Council have held a couple of joint work sessions to discuss some proposed code amendments. There's some tweaks to be made. The council is generally supportive of those proposed code amendments. The plan is to, let me back up a bit. What I've mentioned so far is the primary concern. This code amendment would actually do three things. The second part, which is important, it would address what's currently in the code is it's really a loophole that would allow someone to automatically gain approval to demolish a historic building 6 months after their original denial. So if they originally applied to demolish a historic structure, they received a denial. There's something in code that allows them to come back 6 months later and get automatic approval if they reapply. So the code amendment would fix that loophole. And there's a very third minor thing that essentially allows staff, me, to go out and do site visits for an active application. So those code amendments are proposed to be split into two separate ordinances. One which would address the 6-month demolition loophole. We currently have a demolition moratorium in place for historic structures that goes until November. So the idea is we would adopt that ordinance to fix that loophole, and then we can lift the moratorium. The second package, which we're really calling like the expanded applicability package, we're going to hold 2 open houses. I believe it's April 11th and May 9th, if I have my dates correct. And the intent of those open houses would really to be get some public engagement to inform the public what we're trying to do and what the HPC is trying to do and what the HPC is not trying to do. So the intent is to make sure we have some review process in place for any of those kind of projects that I mentioned, additions to historic structures and commercial buildings, et cetera, outside of off of Harrison Avenue, but also have a very simple process in place, as simple as possible process in place for homeowners who are trying to maintain their home and they want to install more energy efficient windows. They want to upgrade the siding. They want to change out the roof material. So those are changes. It's not just basic maintenance, which would be exempt. And then so we're intending to have essentially an over the counter process where someone would have to apply and receive approval, but it would essentially be an over the counter process for that kind of homeowner upgrades, so to say. So that's the quick version of the proposed in historic district code amendments. Any questions on that?
Is there any consideration about exempting certain things so that you don't have to do an over the counter review? I mean, like, is that a consideration for things that would be deemed, are there, so instead of having to do an administrative review, I guess, to ensure that they are within the allowable exemptions, could they simply be exemptions?
Yeah, that's a good question. Right now, the exemptions, I believe, are limited to, if a building is unsafe, then that would be exempted. If you're keeping the same material, so anything else, we're just regulating the exterior, so it's not the interior. So if you're re-roofing with the same material, asphalt shingle to asphalt shingle, if you are going from lap siding to lap siding, those sort of things. But if you live in Denver and you bought your second home up here and you have shiny reflective metal in your Denver home and you really like that here in Leadville, and so you're proposing to go from 4.5 inch reveal wooden lap siding to shiny reflective metal, then that would require a permit. So if you're keeping the same material right now, those are the exemptions we have in addition to And like an unsafe building, but that's what the exemptions are limited to at this point.
Okay, and then just a quick question about that, just the unsafe building, you know, have been approached to review and inspect for to deem certain outbuildings unsafe, and so certainly want to make sure that, you know, we're queued up together on that
Right,
to make those determinations, and, you know, it's all within the IBC.
Right.
But just make sure that there aren't any questions and that we're on the same page when it comes to those requests for inspection.
right.
In order to deem something unsafe, and, you know, I just be great when we do our follow-up to
Yeah.
just kind of talk through that a little bit.
Yeah, absolutely. I mean, if someone has a letter from a structural engineer that says this building is unsafe and, you know, could hurt someone, then absolutely.
So
That's not-
you want to start, because the IBC doesn't call for that, that leaves that up to the building official to make those determinations. So let's talk,
Okay.
let's determine what that, you know, what kind of criteria, if that's really, that would be outside of what the IBC requires, so we can.
Right.
So we can talk about that.
Right. And that's, the demolition part is already in the code, so I guess the changes that are proposed would not necessarily affect demolition of buildings, just that automatic approval capability.
Okay.
Um,
And then it's the other question, so so all additions to residential, is there square footage on that, or is that just straight across, you know, so if it's a remodel addition, does it have to go through HPC, or is there any threshold for remodel additions?
Right now, the amendments do not have a limit on square footage or specification for square footage, so any addition,
Okay,
a few square feet or, you know, a few thousand.
okay,
And I think the idea behind that is any, you know, even if, especially particularly on the front facade of the historic building. Any addition, even if it's, you know, just a bay window or something that's, you know, 25 to 50 square feet or something, has the potential to alter, you know, a historic building's contributing status to the historic district. And so the concern is we're about to go through a big survey process to survey a lot of our structures and see whether they're contributing or not contributing. And so if you have a contributing structure, this one does an addition to do on the front, that could downgrade to non-contributing, which is, if that happens in repeated fashion, that could be a big deal.
decks, things like that, that are on it.
I think those are the lesser concerns. Yeah, and I don't remember the definition of addition, but I think it's floor area. It's not like an exterior, non-habitable space.
As long as it doesn't have an effect on the facade, but
Yeah, I have to look into that one for like decks and things. I have to look into that one.
yeah, sorry,
Yeah.
and not to, just last question, but
Yeah,
looking
sure.
forward to those, the really exciting town hall.
Yeah,
Open houses.
so the open houses will be at a regular HPC meeting. Will be kind of like the second half of their meeting for an hour. And it'll be available via Zoom and in person. Trying to make it accessible as possible. We've done some we're beginning on advertising, or we have begun advertising for that. And trying to make sure that the advertising is bilingual. And so really trying to engage as many people as possible, because these code amendments, you know, have the potential to affect anyone living in the historic district if they want to do anything to their home. And so we want to make sure that people understand that now there would be a permit required, but it's not, the intent is not to make it overly cumbersome.
Right, I think the sustainability is, you know, key.
Yeah.
And then, so, unintended consequence that endangers
Right.
stability, or housing stability for existing residents. So,
And there's a bit of a challenge there with trying to protect a historic district with a staff member of one.
Yeah.
So,
I get it.
So that, you know,
It's required.
yeah, right.
Chapin, I have a
Yeah.
question. So the boundary of the historic district has certain contributing structures. But the applied restriction for, it would be a permit for any house. Can you explain how all all houses or how that ratio or how that boundary was determined. Even if it's like, I don't know, if it isn't necessarily identified as a contributing structure, but the residential homes are contributing to that, and they are affected, right, by the addition?
Yeah,
Or
yeah,
the
so
work.
not even non-historic homes, new additions. That are within the, like additions to non-historic structures, for example, would be subject to that. review. And you know, those are definitely the lesser concern, right? But there's this thing with historic preservation that a structure can gain, like it can be deemed non-historic in, you know, 1980 or 1970, but over time it can gain significance. And so when we're in a process of doing cultural resource surveys for the entire district, and it'll be a 10-year plus process. We just received a grant to do the west end, so that's like 8th East, 8th, or it's 8th and 9th streets. And so that's gonna be the second phase. There'll be multiple phases over many years. But when those architectural historians come in and they're looking at structures, there may be a structure that is determined, you know, it was constructed in 1970, but it's gained significance over time, and therefore it's contributing to the district. And there are little nuances in there about that. So that's the reason not to just limit it to just historic structures.
Is there, are there state regulations that are not as up for staff discretion that are pretty clear? I'm just like playing devil's advocate of how you might have one perspective and say, okay, well, we should make this easy or whatnot. And also thinking about like historically, I think just, I mean, whether or not it's the definition of the Historic Preservation Society to try to keep your house standing upright and fighting against winter snow weather.
It's definitely something. Do you mind? Okay, it's definitely something that we discussed at the city council level, because it is absolutely the city council's discretion. So it's, you know, elected officials, you know, making decisions for those things that meet the criteria for a certificate of appropriateness for a substantial modification that would go to the city council level. So minor things would be staff level, but if we're talking about things that, you know, like like major additions, which would be considered substantial modifications, those go to city council level. So that, you know, as you know, commission's task is really to take a lot of the workload off and just provide that recommendation for ultimate city council decision.
Okay, and is the district liable to change with the cultural inventory being taken?
The state office of historic preservation has asked the city to look into the boundary. But it's definitely a lesser concern for them than actually having surveys of the structures within the district. In other words, you know, if an architectural historian goes out to a property and they, you know, type up a 10-page report for a house and it says this property is significant because of X, and these have been the modifications and it is contributing. And when someone proposes to come in and make a change to that structure, staff pulls out that document and says, okay, well, you're modifying things that are considered, you know, the things that can make this structure contributing. And so that's really like an important piece. Sorry, I kind of went off topic.
No, that's okay. I get that contributing, like, contributing structures. And I think it's, yeah, it'll be interesting to see it play out with all the others and. I can't remember.
Yeah, sorry. So thinking about unintended consequences, I'm thinking about like grandma who replaces her windows and she doesn't know about this. Is she like getting a fine for that when she's on a fixed income, you know, those kinds of things? But I think those kinds of things, when I read through the document for those changes, those kind of things kind of hit my heart a little bit, you know, or like the fire that happened and that house is gone and they put a modular on that property now, or just those kinds of things seem like unintended consequences with the preservation, but also thinking about longtime residents that are trying to do changes, they may not know that they're, you know, breaking a rule. And then they get this fine or, you know.
What
it's,
is the penalty?
Penalties are significant. Yeah, the penalties that are in there are, in my opinion, kind of outrageous, especially for some of the things that somebody might be in. Yeah. Yeah, or that's the sense. I think there is a real concern. You know, as we're more at the regional housing authority kind of meeting and, you know, about, the sustainability of our existing residents and, you know, an uneducated people trying to just continue to, you know, so I think there's a lot of concerns about the consequences. And, you know, not to use a very bad word or anything, but, you know, from the feedback that I've had, there's a real concern about gentrification, as not the intent, certainly, but maybe an unintended outcome. So, you know, I think there'll be a real need to really, educate, you know, and because, you know, like materials is great, but you know, some people go from asphalt shingle to just a metal roof. Because you know, they believe it has a better shed, you know, snow shed or something. So anyway, it'll be really great.
more
because I know it's still a work in progress, but I think for our local elderly population, fixed income folks, really a worry that they may not be as educated about this, and so there wouldn't be an intent to break a law, but the penalties are pretty. You know, so anyway, so
It's
just
a double take a look at that penalty enforcement section. I've been a city planner and local government for, I guess, going on 9 years now, and I've never implemented a fine ever, you know, and so there's this, you know, thing that happens where you reach out to a property owner and say, you know, hey, there's something we need from you, and I've got a form, and can I email it to you? Can I, you know, I've dropped forms off of people's houses before, those sorts of things, and so. I mean, there's something that's not written in code that does happen. It's where, you know, you're saying, hey, there is something that we need from you. We found out you did this, you know, last year or something, but there's a thing we need to fill out, and someone fills something out, and then it's done. So, and it's like, those metal roof conversion, you know, asphalt shingle, metal roof, and that's like absolutely not a concern, right? So it's, but it, you know, but we have to, I guess the HPC is, and I guess the city council are preliminarily agreeing that there needs to be something in place, some process in place for if a developer comes into town and buys up, you know, a row of homes, and they say, all right, you know, these are, old historic Victorians, we want to make these modern and contemporary, and we want to modify the front facades and put in all glass to bring in a lot of light and everything, and it's a complete change to the character. And so now you're walking down the street as a visitor or resident, and you're saying, okay, my neighborhood just changed a lot. So that's the checkpoint. So there's definitely some balance that needs to be had in there.
So in the interest of time, I'm gonna move us along to get to the next option, next subjects. We have a lot on the agenda. If there's any more questions, I'm sure she would be happy to talk to you at the open housing or through.
Still like so this doesn't affect the Harrison district at all.
In the future, when you're talking about it, it's just like.
Yeah, again, yeah.
Things.
Let's move on to what was next on the agenda? Because of, I think we'll go with ADUs next.
Yeah.
All right, so ADUs, this one's maybe a bit simpler, but so right now in the city's code, ADUs are processed, so ADU is accessory dwelling unit. So by definition, right now, that's something that is, there's several criteria, but it's less than half the size of the primary dwelling unit. So a mother-in-law suite, carriage house, those sorts of things, as we know, those that located on the same property, under the same ownership, et cetera. So ADUs are absolutely, you know, one of the pieces of the puzzle to, you know, to solving the housing crisis, and so it has its, you know, specific place on that spectrum. So right now in the city's code, they are a by right development, so someone can proceed straight to a building permit. And just requires a sign off from the planning department on the building permit. So there's no, city planning or planning and zoning commission or city council review on those. But the city's code does not clarify whether an ADU counts as a unit of density. Because we do have density limitations, and also does not clarify if there's a limit on the number of ADUs per property, per primary dwelling or anything like that. And I was receiving, since I started in August, they're receiving a lot of calls about ADUs, and I've even had a couple come through with, for building permit applications. And so I said, okay, well, I really need to have this interpretation. So I went to the Planning and Zoning Commission and I said, hey, Planning and Zoning Commission, can you answer these two questions? Does an ADU count as density? And does an ADU, is an ADU limited? Is there a limit on the number of ADUs per property? And Planning and Zoning Commission provided the interpretation that an ADU does count as unit density. And there is a limit on the number of ADUs per primary dwelling unit, and that would be one. And so the direction was to work with the city attorney to put that interpretation into code. So that process for that interpretation would essentially be going back through Planning and Zoning Commission and City Council for approval. All right, and so I'm just kind of winging this here. I'm trying to think if there's anything I remember. I'm just gonna pause there, see if anybody has any questions.
Hopefully, quick question, but how does that affect the short-term rental quota? Like, will that ratchet it up exponentially and in a way that we?
No, and that's, I guess, the third little presentation I had on STRs, but the answer is no, because it's, the council provided direction, STRs would be limited on, by a fixed numerical number and not based on a percentage of units.
Okay,
So if you had to increase the number of ADUs, that would not affect the availability of STR licenses.
that sounds good, like a good thing.
And for all this, also these discussions, so let me know if I'm leaving anything out here.
But I would just say that that applies exactly the county code on ADUs. That's what we like to see.
Okay, great. Let's see here, and then moving on to STRs. And so the Planning and Zoning Commission requested a joint work session with City Council, which was just held 2 weeks ago. And the Planning Commission had 4 questions. Pull this up so I don't forget them. 4 questions for the City Council, and this work session was on STRs. And the timing of this work session, what relative to the what's in code is a May 1st point when the number of licenses can be increased based on the 12% of residential parcels. It says parcels in the code. And so the P&Z was requesting this work session, prior to this May 1st date, so they could talk about the number of units. So first question was, should the number of STR licenses available per year continue to be based on percentage of, which is currently 12%, or should the maximum number be changed to a specific number of licenses? So the council's direction on that was that a number of STR licenses should not be based on percentage, should be based on a fixed numerical number. And they requested that the Planning and Zoning Commission come back to the City Council with some recommendations for that number and other things like, for example, should that number increase over time? Should there be a 3% increase each year? Those sorts of things. So just so that's kind of in the Planning and Zoning Commission's court to come back with, do some legwork and come back with some recommendations. But they did decide on a fixed numerical number going into 2024. Second question was, should the density of STRs within the city be limited? So for example, by neighborhood or by block. Some resort communities do that. Those resort communities tend to have hot bed base areas where they have traditional vacation rental areas of town. And some communities are trying to implement density limitations in certain zones, so to kind of stop that transition from long-term rental to short-term rental, but then still keeping short-term rental allowed in those traditional short-term rental areas. So the council's direction on that was not at this time. So no density limitation for STRs at this time. Third question was, should STR licenses continue to require a conditional use permit that would be processed through the Planning and Zoning Commission and City Council. And the City Council decided that no STRs should continue to receive a license administered by the Deputy City Clerk's office. But then also, there should be an administrative process in place for a planning sign off for STR to check for things like parking and trash and anything that could potentially provide a nuisance to nearby property owners. But then there's the City Council asked for a process that could be elevated to City Council if needed. And then lastly, just regarding, I guess, an effort to be consistent with Lake County regulations and council's direction was not at this time. That's the update on STRs.
Any questions for Chapin?
Chapin, currently would an ADU short-term rental license count as an owner occupied or owner non-occupied?
Well, I guess it depends if it's on the occupancy. I mean, is the ADU, is the primary residence owner occupied?
Let's say, yeah. Yeah, so let's say the resident lives in a home and then they have an ADU outbuilding. Would that be an owner occupied STR?
So yeah, and I guess the important clarification there is that there's two sections of code that are regulating this, right? So one is essentially your city clerk's code, which is business licensing and short-term rental licensing, and that's where that class 1 and class 2 comes from, right? So there's a definition. So yeah, I believe because the parcel is owner occupied,
Mhm.
that would be a class 1.
Okay,
But technically that is administered by the city clerk's office. And within the planning code, you have definition for short-term rental. And then, and I guess in the current code, we have like a line item in our table of uses for owner occupied and non-owner occupied, and then how many units. So there's actually like 3 or 4 line items. But there's another code amendment we haven't talked about tonight. It's coming down the line. It's been in works for 5.5 years. That's proposed to remove that. And that was one of the questions to the council is, are we going to remove those line items for short-term rentals in our table of uses? So that, that basically that would provide that distinction, whether or not it would require a conditional use permit. And from this work session, the city council said, yeah, we're just going to say short-term rentals, all different types of short-term rentals are administratively reviewed. So then whether it's owner occupied or not, that goes back to your business licensing criteria.
thank you.
I would just say, it sounds like, I mean, the county's short-term rental licensing since 97 and adopted or amended in 2014 allows, and we do inspection or other like more deeper dives into septics and things that the city doesn't have to worry about, but we also allow like some of that review and like closer inspection for whatever that might be worth. And also for whatever it might be worth, I would anticipate, like, I would agree that the city and the county short-term rental guidelines would look different because we have to consider actual neighborhood like infrastructure capacity with other environmental health issues. So
Yeah, there's a lot of different land use considerations.
Yeah. But thanks.
There's a lot of differences, but as we're on more planning work, I'm looking forward to an opportunity to talk about those together.
Anything else? Thank you, Chapin, so much for your presentation, and if anyone has any lingering questions, you can always email him at his city. Moving right along to our amazing news, DOLA updates.
So we were awarded the incentives grant. It's huge. It's $1,184,000. $1,184,276. And with that, the county and the city will be matching that in 25%. So that's about $300,000. So I'll be sending invoices out tomorrow to the city and to the county for that. So it's huge and it's wonderful. It was very competitive. They did not end up, we thought that they were gonna award to really everybody who was selected as part of that final group to go through, and they did not. So it's huge that we got it, and it's huge that we got everything that we asked for. And now we have some new challenges, looking forward, because we just learned that one of the sites has not been delisted from the EPA, so we're gonna need to start having conversations about that. And pivoting a little bit, so we'll see. Yeah, we'll see.
Likely.
Yeah, we'll see where we end up on that. I changed the agenda also, based on this news. And so there's gonna be some other things that I would like to get permission from the group, to pursue. We talked to the EPA, and unfortunately, I think the timing is not going to work out. The EPA does remediation for free. They do the phase 1 and the phase 2 study for free. However, their grant cycle is you apply in August, you're awarded in October. We have to spend this money by next year in April, so we probably can't do the free option. So we're gonna likely have to pay for phase 1 and phase 2. So I would like to get permission from the board to pursue the cost of folks that will offer phase 1 and phase 2.
We have a motion. The grants.
What is that amount, or is the motion just to,
Pursue it just to figure out the
Pursue it.
amount,
Oh.
and we have money set aside in the ground. We can't spend any of the money until we get under contract with DOLA, and that's gonna take a minute. So, but we can certainly do some research so that we're ready to act quickly, because we have no time. So,
And are we, that's not, I mean. Do we know that we need to wait on that remediation in order to do the infrastructure work?
so
Or
my
do we have to
understanding,
do that
so I
for
talked-
the,
so I
just
talked-
the going vertical?
yes, I talked to Michael, and because it makes sense to me that we could do the infrastructure. And then the remediation would be the top layer, so you would think that you could work on a remediation after the infrastructure, we think, because you're going to potentially disturb stuff, but I guess everything's happening in alleyways and right of ways, and so it's not really on the parcel itself, and apparently that's not, it's still disturbing, and that's not where they would have us do it, so, we need to be very nimble now, so that we can spend this money. And I also, go ahead.
Happy to help with the contract.
Okay, and I talked to Michael today, he wanted to, thank the community and tell everyone congratulations, it's a huge thing. And of course, he was instrumental in us getting this money. So I'm super appreciative of his help, and he broke up with me many, many months ago, and I still call him every day. So,
Yes, thank you, Jackie.
As one jurisdiction to speak at the Rocky Mountain APA conference, and then the Rocky Mountain Land Use Conference, Jackie spoke at that as well. And out of every jurisdiction, I mean, really, Lake County and Leadville were really put it as the model. And they really, it was very much kind of a DOLA bragging about how successful the planning grant had been. And Jackie did an amazing job speaking at that conference. So as a chief of the neighborhood APA, and then I was just running that land use with her, and just did a phenomenal job. So.
I have to say that if they didn't give us the money, it was gonna be a problem. Because that was incredibly stressful, because I don't speak.
Thanks for your tips on it.
Yes. And then there was some other stuff, and I'm having trouble opening up my own stuff, so we can see what else is on there.
I was having issues too, but let's circle back to the motion. Do we have a motion to direct Jackie?
To direct staff to pursue costs for phase 1, phase 2 environmental studies.
Second,
Second.
any other discussion? All in favor, please say aye.
Aye.
Any opposed? Any abstentions? Great, all were in favor.
So, and then board direction on speaking with local sanitation and Parkville Water regarding cost sharing for engineering. And review of procurement procedures, willing to participate with us on this project. So apparently that's the next step that I need to, for you to also, give me direction on, so that I can go ahead and set that up.
You is that presenting at the third board meetings?
Yes, so we already,
Like nobody's.
so we already did this and they said yes, but now, yeah, so now we need to go and actually. Talk further about it, but so I need your permission, I think that's what I'm asking for on that.
Motion to give permission.
I'm going to speak to Parkville Water and local sanitation about cost sharing. We have some money set aside in the STOLA grant for engineering and surveying and that sort of thing, so.
Maybe you talk about tap fees. Wait.
Well, I did talk to Dan Osborne about that fees at the Summit 101, and he said they would be maybe open to that conversation, so.
I talked to Teeter too at Parkville, and he said they would
Yeah.
do affordable, a different rate.
I don't know if you want to combine that into one
Absolutely.
presentation.
Yes, I would love to combine that into one presentation. I think that's a fine path forward.
I move for staff to engage with the Parkville Water District Board and the Laville Sanitation District Board on discussion on affordable housing tap fees and sharing costs for engineering and other things.
Good luck. Do I have a second? Second. Any other discussion? All in favor, please say aye. Aye. Any opposed? Any abstentions?
And if you do want someone to go, nose goes. Somebody else can go.
That's scary the last time. So.
Jackie, do you think you would need a board member alongside with you?
I think that a board member with me would be wonderful. That would be wonderful.
Well, actually, it doesn't make sense as, yeah, I'll be fine. I don't think there's any conflicts there.
Then the next thing is also to start looking for bids on surveying, both Alta and boundary surveys. So again, just trying to get ready. So just want your permission to start pursuing that.
I don't know if it's helpful, but just in the interest of like working together, the city council did ask us to engage with a surveyor for some property on 11th Street. So we have engaged with Marson Engineering,
Okay.
so they're already be up here surveying city property. And so if that's helpful for economy of scale, while they're up here at the same time, since they're out of Avon and Breck.
Okay, they sound expensive. Excellent.
I think they were the most expensive bid.
I'm here to spend money.
A motion to give Jackie the ability to pursue how do you put that?
Getting
Pardon?
bids for surveying.
Surveying with a potential partnership with city.
So moved.
Great. Second. Second.
Who
Um,
seconded? Nice.
Great. Any other discussion?
Is it limited to the 3 sites or do we? Are you thinking other places?
We're not limiting anything.
Okay.
Perfect. Good.
Survey it all. We all need it.
Any other discussions, comments? All in favor, please say aye.
Aye.
Aye. Any opposed? Any abstentions? Great, all were in favor. Any other things we need to give you permission on, Jackie? Perfect. Other funding opportunities.
So, also, we applied, at the last minute because I was sitting next to Max and he told me about the, toolkit, which is also through the same House Bill 1271, the planning grant and incentives grant we're in. And I was a part of the focus group now, and I missed it. That deadline was that day, but I was sitting next to Max at, the table at the Elks during the Senate, gift card giveaway. Anyway, so we applied for that, and we're going to have a conversation to see how they can maybe help us on Monday at 10 a.m. So if anybody wants to be included in that Zoom call, but that may help us with capacity, and we'll find out what kind of things they will be able to offer us. Then the other funding opportunities. So our lovely friend John McMurtry has generously provided us with his grant writer, and Katie, I'm gonna let you say her last name. That's right. She's a delight. And so we worked last week on applying for 2 additional funding opportunities for another $1.7 million. One is the 2024 congressionally directed spending that went to our 2 senators, and then the 2024 House Appropriations Committee went to our Congresswoman Brittany Pedersen. And Katie was great. She reached out to the governor's office for questions and clarification and so forth. The deadlines were, it was a very quick turnaround. The first funding opportunity was, we applied for that last Friday. And then the second one, the application was submitted yesterday. So that's huge. So we'll see what happens from that. There's additional funding out there, Proposition 123 that you saw on the ballot. We're just learning about that right now, so I don't have a ton of information on that. And that's all I have.
That was our last item. Finances, we just went ahead and covered.
No, we're gonna do that next time. And
For
the April 5th meeting, so that's the strategic planning meeting that Tim is going to lead. Tim Hill cannot attend that. He is unavailable on the 5th and the 6th. And I think it's important that all the board members are present for that conversation, so I would like to reschedule that. And while he said he's available any other day in April. So I would love to find out when the rest of you are, because I don't want to do this by you now.
So any day but April 5th.
5th and 6th, he is unavailable.
Fridays are my kids are paid, so I don't have one meeting, so I can move
Okay, what time?
whatever the-
We had 2 hours set aside last time, so. Does 8:30 to 10:30 work again?
8:30 to 10:30, 7 works for me.
April 7th.
That is a Friday.
April 7th might not be great for me. Okay, it's Friday, kids are not in school on Friday.
Could we provide child?
They want to come to my house.
All these trampoline up.
Yeah.
Will that work for you?
Could we do a non-Friday?
About 12. Wednesday.
It's Arkansas Basin meeting.
13th. Thursday.
I
14th. Friday. We can't because Friday's got. 17th. Monday.
Is it a long weekend then?
No, that's previous weekend would be Easter weekend. 18th,
So the 10th is out.
20th doesn't work for me. 21st doesn't work.
I think we kind of need to address this sooner than later, because we've got so
Yeah.
much going
Do
on.
weekends work? If, well, third, does the third work for anyone, for everyone? Yes. Otherwise, we seven's a weekend territory.
That's good.
Third is good in the morning.
Yeah, it'd be same time, same morning time.
Okay, 10:30 on April 3rd.
Works for me.
Works for me.
I'm just gonna throw this out there. I'm having back surgery on the 27th. I'm hoping they cut it, so.
All right. So,
I probably won't be there for this, but
sounds like Monday,
no, we should not wait. We need to move forward.
Okay.
Monday, April 3rd sounds like our date, from 8:30 to 10:30. So mark your calendars.
Yes.
All right.
Any other updates from any board members? Or committee members that pertain to regional housing? Okay, time is 7:39 and this meeting is now adjourned.
So when nobody remembers that the city said and approved the budget, that we were gonna come back for the money. Remind them.
I will. Very good point.
Okay. Well,
Thank you, everybody, for coming.
thanks, Jackie. Hey, thanks for dinner too. That was a lovely.
Can you eat more?
Right. I'll help you carry it.
I appreciate that. I know we have so many, we gotta put this back spot. So you gotta put the living room and.
Sit down.
Yeah, let's do it. Jackie, do you want this back?
Yeah, so I'll send you, or I'll see you, when can I see you? And I'll give you a printed version. of the Agenda, if you want a printed version.
Not at this point. I just use it during the meeting. Yeah, it's all good.
I was talking to Michael 5 minutes before I left. And he's like, you need to do this, you need to do this, you need to do that.
So we can find that.
And she was like, "You can have
Oh,
it
I just accidentally handed it to her.
Harrison,
Jackie, can I get that back?
So building on the blocks. You wanna read the date? They can't read it, I write it.
Okay. This. Yep. Is the 15th day. Hey, March. The kids keep thinking it's May. Yep.
Your government in any of
You're like, but it's already May.
bill.
Wrong month.
Yeah.
It's
Got it?
Yeah.
Okay.
Special bill, not one big bill.
Yeah, I think.
Yeah.
Yeah, they.
Well, yeah, I mean, there are vacant.
Yeah.
properties that are up for sale. So,
Yeah, they get us.
Yeah.
I mean, if you want to see, just check our. website. Yeah,
If it goes to public record, so.
And this would be a. Maybe deciding on acquiring this.
There's the-
Nature.
Scott, I got it.
Oh, okay. Yeah.
Deadline is Friday.
I know, that's okay, I can do it. I'm ready.
But, yeah, but I know that. Yeah.
As you've given them away now.
Yeah.
Yes.
Board or anything.
Yeah.
I love when people don't know. It's good.
Right.